Manever I say ma PENDREAM TV. PENDREAM TV there, see them yopo.
You are once again welcome to PENDREAM TV, the only channel that brings you the best and latest updates in politics. If you are new here, please don't forget to subscribe to the channel, hit the notification bell, turn it to all posts so that you'll be the first to receive any latest updates that will be loaded onto the channel. You can also share to other members to watch as well. Make it go viral for us. Thank you. I want you to join me listening to what the former ambassador to Canada have to also say about the interference of the Supreme Court into the parliamentary proceedings, which he said what they did was actually an assault on the constitution and not parliament. Without much ado, I would like you to join me listening to what he said into detail. Thank you.
Dr. Tony Aidoo into this conversation. He, of course, is a senior member of the NDC. Dr. Aidoo, it's a pleasure to speak to you. Good morning. Of course, forgive me, Dr. Tony Aidoo was also Ghana's ambassador to the Netherlands. Dr. Aidoo, good morning to you.
Good morning.
Thank you.
How are you?
Very well, thank you, and thanks for your time with us this morning. So, well, drama in Parliament, but you have always been of the view that the Supreme Court's ruling should not be observed by Parliament. Why is that?
Because the Speaker of Parliament applied a provision that automatically kicks in. The Speaker of Parliament did not make a ruling or an order. Article 97, Clause 1 and the sub-clauses operate automatically. They are akin to what in criminal law we may say you are guilty because the law says you are. Strict liability under criminal law. Let me give you an example of strict liability. The law says you must have a driving license before you move a vehicle. You don't have a driving license, you are guilty. Whereas other criminal offenses will have to be proven on the basis of what we call the actus reus and the mens rea. Mens rea means you had a guilty mind. With strict liability offenses, the court and the prosecution doesn't have to prove mens rea. The law kicks in automatically and registers your guilt. That is how Article 97 and its subclauses operate. What the Speaker did was to apply on the basis of a clear evidence that that provision has kicked in. The Supreme Court has no duty nor power to interpret acts which are clear. They are clear. There is no ambiguity in the operations of Article 97 and its subclauses. What the Supreme Court has done, therefore, is an assault on the Constitution, not an assault on Parliament, an assault on the Constitution. The Supreme Court is a creation of the Constitution. So are the standing orders of Parliament a creation of the Constitution. Then there is the principle of separation of powers. The Supreme Court cannot operate as a supra-constitutional court with the power to interfere with parliamentary proceedings. What the Speaker did was to apply the proceedings of Parliament. He did not interpret, and he did not rule.
Right. Dr. Aidoo, if I may, what do you say to just that Well, the Supreme Court has not actually yet ruled on the substantive application brought by Afenyo Markin.
It is interfering. It is interfering with parliamentary proceedings, and it has no power to interfere with parliamentary proceedings.
Dr. Aidoo, you've indicated that the Speaker only applied a provision. You've likened that to the criminal proceeding, strict liability. But there are those who actually, and I'm sure you may have read, writings by Professor Kweku Asare, who says his understanding of that provision is that it's futuristic. And so if a member of parliament does not leave his side and intends to contest on the ticket of a political party, if it's independent, or say he came on the ticket of a political party and decides to run as an independent candidate, that person must not lose his seat per his understanding of the letter and spirit of the Constitution. Isn't that enough reason?
If that is acceptable, then the provision of Article 97 sinks into absurdity.
Right.
I was a member of the Consultative Assembly.
Okay.
And I recall the debate of this provision. Originally, the technical people who presented it only related it to crossing carpet from one party to another. But there was an amendment that included the independent candidate. The principle is that you came to Parliament on the basis of either a party ideology and ticket or a pledge to your constituents. And in good faith, you were voted into Parliament. If you decide to break your side of the bargain, you have kicked in Article 97. And to the extent that Article 97 is clear, it does not lend itself to any interpretation. The Supreme Court has no right to interpret the Constitution, except where there is ambiguity or where there is a procedural error of illegality by the Parliament or a procedural error of irrationality.
Okay. Now, talking about ambiguity, just so we are all clear, you say cross carpet. In this conversation, the phrase cross carpet has been used to mean leaving one side to the other.
Yes,
as
a descriptive word.
Yes, leaving the majority to the minority or vice versa. But that is not what has happened in this case. So the question is, what is the justification?
Why? The Speaker doesn't have to justify anything. So long as the provision is clear, unambiguous, it says a member of Parliament must vacate his seat and the conditions follow. That is clear. It doesn't lend itself to any interpretation. Neither is it futuristic. Otherwise, the whole provision becomes a matter of absurdity.
But Dr. Aidoo, where there is a dispute, where some believe that this is the
there can be no dispute.
One minute. Where some go to the Supreme Court.
Excuse me. There can be no dispute as to invite the intervention of the Supreme Court to interpret.
Where people go to the Supreme Court, inviting the Supreme Court to interpret, what wrong will the Supreme Court do if it interprets?
It cannot interpret a constitutional provision that is clear. How is it going to interpret? Okay, let's, for the sake of argument, allow the Supreme Court the levity to interpret. What interpretation is it going to use? Purposive interpretation. Purposive interpretation, as will be attempted by the Supreme Court, must not be constructive, but must refer to the intention of the framers of the provision, which means the reference document should be the Hansard of the Consultative Assembly. That's where you get the intention of those who framed the Constitution. You cannot construe the purpose by your own construction.
So, well, Dr. Aidoo, as you're aware, there are those who disagree with the language of the Constitution in Article 97 is clear. There are those who disagree.
It's
so
clear.
Well,
it's clear.
There are those who disagree with this. So what is the remedy in a situation where there is disagreement on the clarity? Is it not to go to the Supreme Court?
No. No, the Supreme Court must know the bounds of its jurisdiction. You cannot interfere with the proceedings of Parliament. And these are parliamentary proceedings.
Dr. Tony Aidoo.
The Speaker applied a provision that kicks in automatically. The Speaker did not interpret or rule.
Now, Dr. Tony Aidoo, you would agree that once there are different views on the meaning of a law and definition is in dispute and controversy, the interpretation of the Supreme Court is needed, isn't it?
But you keep saying interpretation. Interpret what?
Because while you say plain words cannot be misconstrued, which is true, others have also said what is written in the Constitution, which you say is plain and clear, also means something else. How do we settle it?
Else, except in the ordinary sense of the English words used. A member of Parliament must vacate his seat. That is the operative words or clause. Must vacate. The Speaker did not interpret it. He only applied the provision. So where is the ambiguity? Where is the confusion? The Supreme Court must know that Parliament is a chamber of politics. So there will be disagreement between the members of Parliament. But it must allow the Constitution to work. It should know the bounds of its jurisdiction.
Speaking of the bounds of the Supreme Court's jurisdiction, it brings us back to the question of whether or not we aren't caught in a discussion about the substantive issue when the Supreme Court has merely stayed the hand of the Speaker.
And it has no right to stay the hand of the Speaker. It has no right to interfere with parliamentary proceedings. The Supreme Court has no authority to interfere with parliamentary proceedings.
Why do you say so?
Because of the principle of separation of powers. Otherwise, the Supreme Court will be setting itself up as a supra-institutional body.
But Dr. Aidoo, the principle itself has limitations. It allows, for example, the limitations includes, of course, it is also a balancing act. So separation of powers and checks and balances.
Yes,
the check here is that there is an expectation that if I file a case at the highest court, asking that something that has been done be stopped, or there's a temporary hold on it until a matter is determined, that court will come in.
Which court has the authority or the power to stop parliamentary proceedings? Proceedings. We are not talking about an act of parliament that is ultra vires or irrational. We are talking about parliamentary proceedings. And parliamentary proceedings is a function of the Constitution itself via the standing orders of Parliament.
Dr. Aidoo, how does your argument stand against Article 99 of the Constitution?
What does it say?
Which suggests that, in fact, the duty of determining whether or not a member of Parliament has left his or her party is to be decided in a high court, not even the Supreme Court.
Article 99 didn't say so. It says the declaration of vacancy.
Forgive me. Thank you.
It should be a matter for court decision.
Thank you for the correction. Yeah, so that is indeed a parliamentary matter being decided in a high court, is it not?
No, it is not. It is not. It bears on human rights. the right of the MP to be in Parliament. But the right of the MP to be in Parliament has been abrogated by the MP himself. And this is not a matter for interpretation. It goes to the tribunal of fact. Is it a fact that you have cross carpet? Yes, it is a fact. Not subject to interpretation, which we'll call in a court.
Right. Let's talk about what's happening this morning. The minorities, well, the NDC side of Parliament has assumed the seats in the on the majority half of the chamber. I'm interested in your take on this. I mean, do you believe that is a lawful way of proceeding?
On the basis of the Speaker's declaration of a vacancy, as he is duty bound to do under the standing orders, the balance of power in Parliament has changed. Now, what do you say about the presence of the military in the Parliament? It's a threat. The military has once invaded Parliament. That was an act of treason. If they invade Parliament again, they have committed treason against the Constitution, not against Parliament. The Constitution is the supreme entity in Ghana. Any attempt to assault the Constitution is a treasonable offense.
We are given to understand that the military were actually there as a routine, as a part of a routine exercise they carry out every Tuesday.
They started going there since yesterday. It was not a routine. Whoever called them is engaged in a conspiracy to commit treason.
We are made to understand that they have actually left the premises of Parliament as we speak.
Thank God for that. Thank God for that. Ghana cannot stand these disturbances anymore. Let the Constitution govern. The sovereignty of Ghana is in the Constitution, not in the Supreme Court, not in the executive, not in Parliament.
What would be your expectation if the Speaker walks in this morning and rules that he is going to abide by the Supreme Court
Then
ruling?
he's checking out of his duty and responsibility. And it is this that is encouraging the Supreme Court to constantly assault the Constitution. Assault on the Constitution is becoming one too many. The Supreme Court must realize this bounds, that it cannot interfere with parliamentary proceedings. It's about time.
Where does the remedy to what you consider an assault on the Constitution lie?
The remedy lies in the application of the Constitution in its true sense. We must observe the integrity of the constitutional provisions.
By which institution?
Until an act of Parliament offends the Constitution, the Supreme Court does not come in.
I get your point. I'm asking, who can call the Supreme Court to order if you believe so? Would it not be true?
It's unfortunate that Ghana does not have an administrative court that could subject the Supreme Court and its rulings to critical observation.
So you would agree?
It is encroaching on the preserve of Parliament.
So you would agree that it would have to be going before the same court to try and get it to change its ways if one disagreed with it?
Would it change its own ways?
In fairness, this was a panel of 5. They are more than that.
It's a way of hurting a country. And we are in a fascist regime. Conquer the state apparatuses, manipulate them, and use them towards your own interest. That is fascism. If the military had remained in the premises, it would have been akin to Hitler's invasion of the Reichstag in the 1930s in Germany.
Now, the question I was asking here is that since this panel was a 5-member panel, and we know that a review can take a higher number than that, would you not hold your horses until, say, all of that is exhausted before you can come to the conclusion that there's no hope in going back to the judiciary for a remedy?
A review by a Supreme Court that is highly compromised, a review by a 7-member panel,
Yeah.
9-member panel, 13-member panel. Every appointee of the Supreme Court today is an appointee of Akufo-Addo. That is what we call manipulating state institutions.
Dr. Tony Aidoo, there are still some justices of the Supreme Court who were not appointed by President Akufo-Addo.
Who empaneled the Supreme
Yeah,
Court?
but I'm just trying to say, I mean, Justice Gabriel Poaman, for instance, was not appointed by President Akufo-Addo. He's on the Supreme Court. Justice Bafuboni is still there. He was not appointed by President Akufo-Addo.
He was appointed by an MPP president.
But not by President Akufo-Addo. But you can
He
go
was
on.
appointed by an MPP president.
Well, so at this point, the question is how to remedy the situation. And
The remedy, as I said, lies in the Constitution, in our commitment to the constitutional provisions.
So who
The
do we...
remedy does not lie in the rulings of the Supreme Court that is highly compromised. Ghanaians must know that the Constitution is our property. It carries our will, and then we must support the Constitution.
So who do we look to set this right
We
using
look
the
to
Constitution?
Ghanaian populace to set things right.
How?
They must insist. Ghanaian populace must insist on the operation of the Constitution.
So you're suggesting we hit the streets?
Whatever it takes for people to pay attention, that there is an veritable need to defend the Constitution against the incessant assault.
So you wouldn't recommend anyone making an application to the Supreme Court to remedy this?
The Supreme Court will not remedy it.
Should we not give them the benefits of the doubt?
It's an irrational order. It is an assault on the Constitution itself.
Should they not be given the benefit of the doubt?
What doubt is there? Look at the contradictions that have attested the rulings of the Supreme Court. You say the current 4 MPs have a right, the constituencies have a right to be represented. Didn't the people of South for 4 years had a right to be represented? Didn't the constituencies of Jackie Kwesi had the right to be represented? What kind of situation do we have at all? Huh?
Dr. Aidoo,
A compromised Supreme Court.
Dr. Aidoo, if your assessment is fair, then is it your view that rule of law has collapsed? If you're saying the only solution is to hit the streets?
What I'm saying is Ghanaians must stand firm. The Speaker must stand firm. And if we stand firm, you will find that tyranny will recede.
Well, this has certainly...
Don't give way to tyrants.
This has certainly been enlightening, Dr. Tony Aidoo, and we are grateful to you for your time with us this morning.
Thank you very much.
Yeah, you've been listening to Dr. Tony Aidoo. He's a senior member of the NDC, and he also was Ghana's ambassador to the Netherlands.
Thank you for watching. PENDREAM TV really appreciate your time. Please, if you are new here, please, I'll urge you to subscribe before logging out, so that you'll be the first to receive any latest update that will be loaded onto the channel. Thank you.
PENDREAM TV now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.